Hello, everybody, and welcome to another edition of In Conversation Live. I'm Roger Kirby. I'm currently president of the Royal Society of Medicine, and it's my honor and my pleasure tonight to introduce to you Professor Celia Kitzinger. I'm just going to read out her rather impressive CV to you. She's an academic psychologist and an honorary professor at the School of Law and Politics at Cardiff University. She has a 40-year career in academic psychology. Her research has encompassed three main areas: gender and sexuality, conversation analysis and medical communication, and prolonged disorders of consciousness and end-of-life decision-making. She's a prolific blogger on these issues, and she is co-director with her sister Jenny Kitzinger, who we'll be talking about, of the Coma and Disorders of Consciousness Research Centre. She's co-director and co-founder with Jill Looms-Quinn of the Open Justice Court of Protection Project, and co-founder with her wife, Sue Wilkinson, of the charity Advanced Decisions Assistance. So hi there, Celia. Thank you so much for joining us from a slightly rainy Lake District, I gather.
Yes,
Celia, we often say these programs are a bit like Desert Island Discs, but without the music. And we sort of start with a bit of background of our speakers. So tell us a little bit about your very famous mother, Sheila, your dad, who I think was a refugee from Germany, and then your brothers and your sisters and your whole family. So give us a bit of background before we start getting into the academics of loss, brain damage from catastrophic brain injury and so on. Yeah, over to you.
So I think the key reason why my family background is significant in terms of thinking about my work subsequently has been that it was a family where human rights were key, were discussed a lot over the dinner table, were often the subject of massive arguments between us where we were expected to take positions and disagree and argue about them. So my mother was a social anthropologist and childbirth educator and activist. She died 6 years ago, who worked on human rights for women in childbirth and choice for place of birth and mode of birth, and worked on things like shackling of pregnant prisoners when they were giving birth and court authorized cesareans for women who didn't want to have cesareans. She was concerned about the medicalization of birth, and also introduced me very early on to the idea that medicine could be harmful as well as a source of good. And she was absolutely committed to control over our own bodies, not handing us over to medical professionals. And I did subsequently do some work with her on women in crisis after childbirth as one phase of my academic career. My father, yes, was a refugee from Germany when he was about 11. It was about 5 weeks before war broke out in 1939. He subsequently worked on refugee and asylum issues. He was involved in the charity Asylum Welcome, but he's retired now. He's in his 90s. But his last job was as president of Templeton College, Oxford, which is now Green Templeton. And a nice thing about that actually is that Green Templeton runs a program called the Sheila Kitzinger program, which is a funding organization that hosts campaigning activist activities around things that my mother cared about in relation to not just childbirth, but other issues of political and social importance. So that's very nice. And we were also brought up Quaker, which is the Quakerism that we were exposed to was about very much that Quaker maxim, speaking truth to power, and about seeing the light within everyone, including the people that you very much disagreed with. So I think it came out of a background where it was natural for me to see personal experiences as the personal as political, and to want to change things in the world and make the world a better place.
Right, great. And then I listened to a radio program where Eddie Mayer interviewed your sister Jenny about your sister Polly, and I think that was a kind of certainly a life-changing experience for her, listening to her, but for you as well. And that was the trigger for some of the work that you've done, the amazing work that you've done on patients with catastrophic brain injury. So tell us just a little bit about Polly and the injury, and how that kind of raised so many issues that you're now dealing with.
So Polly is my younger sister. Jenny's the youngest, Polly's in between. And she was a disability rights activist. She was passionate about the voices of people without power being heard. And she enabled that for the people that she worked with. She was also passionate about the right to make her own decisions, including decisions that other people thought were unwise. You always knew what Polly wanted. You always knew that Polly's views mattered a lot to her. So when she was involved in a car accident in 2009, she was 48, and suffered a catastrophic brain injury from that. We were told within a few weeks that she would always need 24/7 care, and that she would never recover enough to make her own decisions or to be independent again. It was fairly obvious to us that she would not then wish to receive continued treatment. So a lot of the emergency treatments had been given by that point, and she'd been kind of brought back from the brink, but the continuing treatments included antibiotics and at some points ventilation, but the main continuing treatment was the feeding tube, clinic assisted nutrition and hydration. So for the first 2 years, when she was unable to swallow at all, or not enough to keep herself alive, they continued to feed her through a tube, clinically assisted nutrition and hydration. And the whole family was certain that the Polly that we had known for nearly half a century would not want that. And we said so. And we took in her letters, her diaries, her poetry. We wrote letters of our own reporting conversations that we'd had with her. They all stopped short of saying, if I'm ever catastrophically brain injured and in first a vegetative state and then a minimally conscious state, I do not want treatment A, B, C, D. They weren't the formal documents like that, and they weren't signed and witnessed or anything, but they were very vivid, very clear expressions of her values, of the things that mattered to her, of the absolute premium she put on independence, on autonomy, on her right to make her own decisions, none of which was going to be possible for her anymore. And we said she would not want this, and Polly would want to refuse this treatment. And the doctors ignored us, and treatment was given for 2 years. And subsequently, she learned to swallow again with enough. And now there is no treatment to withdraw. And 11 years later, she is living in 24/7 accommodation and can't make her own decisions and would not value the quality of life that she has now. So I think that what that did, that was a hugely shocking experience for the family, that doctors would, it felt like, kidnap our sister and treat her against her wishes as we represented them to her. And as a family for whom human rights are important, and as a family who knew Polly and loved Polly and were very aware of Polly's views, it was very shocking and very and beyond belief, really, that this could happen, that this would be done, that it felt like torture. And of course, what my family does in that situation is try to figure out, with the resources at our disposal, how did this happen to us? Does it happen to other families? How many people are in this sort of situation? Why do doctors do it? And can we change it? Can we make sure can we rescue something, some legacy from this experience that would mean that other families don't go through this experience?
And this is not a one-off. I mean, obviously, it was an individual injury, but we're talking about thousands of patients, aren't we, around the UK faced with catastrophic brain injury. I mean, trauma is one, I suppose. Stroke is another. Anoxia following a heart attack might be another, et cetera, et cetera. So these are. I was talking to Lynn Turner-Stokes, who might send a question in, who's a much more expert than me on these issues, and she was saying that it might be 10 or even 20,000 patients around the UK in this situation. So, explain then what you and Jenny did in combination with the other members of the team to kind of, in the light of your own personal experience, which obviously you felt unsatisfactory. How did you go about making the changes which we come on to talk about?
I would say, first of all, that you are absolutely right, that there are huge numbers. Nobody quite knows how many. I think the government estimate is up to 16,000 of people in vegetative or minimally conscious states. Right. But we didn't know anybody who had ever been in that state. And I think for most families, that's the condition that they find themselves in, that you may understand what some kinds of brain injury are like. You may have experience of some forms of disability. You may know people with dementia, but you don't know the devastation of keeping someone alive who is unconscious, or is going to be virtually unconscious forever, or is going to recover with that kind of loss of capacity that is involved in these kinds of catastrophic brain injuries. So I think our first experience was total isolation and not understanding what was being explained to us about the vegetative state or the minimally conscious state. So what we first did was we reached out to other families. Through Polly, really, through the units that she was on, we met other people, other families, and began to talk to them, and began to realize how common it was and how shocked all of these families were about the situation that they'd suddenly been thrown into unprepared. And our first move really was then, because we're researchers, because we're academics, because those were the skills at our disposal, to do some formal interviewing with family members about what their experience was like, with the aim of sharing it amongst families so that people would feel less isolated, and also sharing it with doctors so that the clinicians who were delivering these treatments and engaging with families could begin to understand what families were going through from the other side, that there would be some sort of reciprocal understanding from them. And we also then developed interviews with the clinicians. Lynn Turner-Stokes was actually one of them very early on, and we built an online resource for Health Talk, which consists, it's online and anyone can go and look at it, and it consists of family members talking about how the person came by their injury, how they first heard the news, what it was like, what it is, how they think the person's treatment is going, what their hopes are for the future, problems of visiting the patient, their concerns about current health issues for the person, all the sorts of daily concerns that families in this situation have. And of course, should the person be continuing to get clinically assisted nutrition and hydration? And that's a whole set of video clips from family members talking about their experience with medical expertise in there as well. And that's an incredibly useful resource. And many families have since contacted us because of that resource to say, that was really helpful. Now this is the situation I'm in. Can you help me? Mm-hmm. So the next stage, really, after having set up the Health Talk resource, was that families were contacting us wanting help. And what they wanted help with was sometimes getting better treatment and finding ways of improving the current condition of someone. What very often they wanted was information about how a feeding tube could be withdrawn, how a person could be allowed to be at peace, how the dying process could now not be extended anymore. And that began to mean that we started to accompany families to best interest meetings, to help them to speak out to doctors so that their voices could be heard. We began to help families think through what the person would have wanted and write letters explaining that. Ultimately, we began to accompany families to court hearings in order to ensure that the best interest decision was made by the person, by the judge for the person. We began to talk to doctors in this process. So if we were helping a family, we would begin to start contacting a doctor and saying, why are you continuing to prescribe formula feeding every week? How do you know it's in this person's best interest to do that? Do you have minutes of a best interest meeting? Because actually the family are telling us they haven't been consulted and there hasn't been a best interest meeting. Is this just happening by default? Because that's not what the law says. It became clear that people didn't understand what the law said. And subsequently, both Jenny and I were involved in 2 different guideline groups, which seemed to be a really important next stage because clinicians were not clear about the law. It's not just doctors either, it includes speech and language therapists who are often involved, physiotherapists, nurses, the whole panoply of the multidisciplinary team who converge on these patients. So the 2 guideline groups that we were involved in co-authoring guidelines were the British Medical Association guidelines on clinically assisted nutrition and hydration, and the Royal College of Physicians guidelines on prolonged disorders of consciousness. It was really important to get the family voice into both of those and to make sure that there was more than just a medical and medico-legal approach.
So just to help some members of the audience, we've got a lot of clinicians, but non-clinicians listen to these programs as well. So catastrophic brain injury affects the upper parts of the brain, the parts of the brain that deal with consciousness, the frontal lobes, etc. But in the acute state, patients need ventilatory support using respiration on the ITU, but they get to a stage where they can breathe spontaneously, but they have effectively no consciousness, but they can't swallow, they can't feed, even if you kind of spoon feed. So they have to have either a nasogastric tube or what they call a PEG, I think, isn't it, inserted into the stomach. And I suppose, I mean, what I'm hearing from you is that, and I can see this happening, is the medical and nursing team sort of adopt the patient and they make the decisions on the patients, and the family somehow their views are not really taken into account because the medical people say, well, our patient and we're making the decisions. Is that a reasonable summary, would you say?
Well, yes, because the law is that families are not the decision makers in these cases. The decision about whether or not to give a feeding tube needs to be made in the best interest of the person by whoever's inserting a feeding tube. Mm-hmm. Whoever's putting the formula down that feeding tube needs to be sure that it's in the patient's best interest before they do it. So it's going to be the clinicians and the professional carers who are the decision makers in these cases, not family. And I think, again, this is a very great shock to people who believe that next of kin will be able to make decisions for their mother, their father, their spouse, their child. And it's not the case unless somebody's appointed that family member with a lasting power of attorney for health and welfare. The decisions are going to be made by whoever's giving the treatment. And that is the law. They're supposed to consult family, and they're supposed to ask family about the person's values, wishes, feelings, and beliefs, and what they think the person would want in this situation. And that's what happens in a best interests meeting, theoretically. But family are not the decision maker. If family had been the decision maker, Jenny and I and our parents and the family would have made a decision for Polly. We're not legally able to.
Yeah. Well, there's a good question coming in from John Wilkes. Thank you, John. And please do send any other questions in that you'd like Celia to address and us to talk about. John says, does best interest audience meeting, its protocol, also apply to folk with dementia who may not be able to advocate for themselves. So I suppose there must be many, many thousands of patients with dementia. And I said, is that slightly different because it's a chronic, slow process rather than the acute catastrophic brain injury that Polly suffered from a car accident? Well, how does the dementia situation fit into the overall picture, Celia?
So there are obviously differences. With dementia, you know that there's going to be a decline. With catastrophic brain injury, there is the possibility, often the reality, of some sort of improvement over time. So they're going in opposite directions. There are other differences as well, but the basic question, does the best interest meeting and its protocol apply? Absolutely it does. So as soon as it appears that a person doesn't have the capacity to make their own decision, whether it's because they're unconscious, whether it's because they have advanced dementia, whether it's because they have a learning disability or a mental health problem, or a phobia, whatever the reason why the person seems not to be able to make their own decision, then there are various steps that should be taken by law. And the first one is to try to find ways of supporting the person to make their own decision. Maybe with easy read materials, maybe, I mean, you can't do that with someone who's unconscious, obviously, but in many situations, such as dementia, there may be a time of day when somebody is more alert. There may be a person with whom, a carer with whom the person with dementia is more able to speak and to communicate. So there may be ways of helping the person to make their own decision. If that's not possible, then if they cannot make their own decision, you move into the best interest scenario, which means that a decision must be made taking into account what they seem to want now, or what they would have wanted and what they would have wanted before, but taking into account also other sorts of considerations that the clinicians themselves will bring. And yes, you need to consult family members and engage in the full best interests process. And dementia is one of the most common impairments of mind or brain that the person at the center of the court of protection hearings that I watch, dementia is the most common, pretty much.
Well, there's a question from Sarah Wooten, who I know is the CEO of charity Dignity in Dying. And Sarah says, do you think it's true that the family voice is always considered secondary to the medico-legal view in medical decision-making? Why do you think that is? And do you see that changing in the future?
Unless the family has, as Sarah well knows, a lasting power of attorney, they're not the decision maker. So I don't know that secondary is quite the right word, but they're not the person making the decision. The family are contributing to a decision, or should be, but it's the doctor or the lawyer who is making the decision. So obviously family views about what should happen don't carry the same weight. And I would say that's one of the reasons, if you want your wife or your husband or your adult children to make decisions for you when you cannot, you must complete a lasting power of attorney for health and welfare, assigning them that right. And then it takes it away from the doctors and the judges. It gives it to the person that you want to make the decisions.
Right. Well, Lucio Fumi says, why don't we try and encourage people to write their advanced directives when young and healthy as a form of mass advertising? I wrote mine when I was 50 and had the document countersigned both by my wife and my GP. And I suppose you'd agree with that, wouldn't you?
If there's any treatment that you would want to refuse under some circumstances, then yes, you need to write, it's actually called in law, an advance decision to refuse treatment. And I think people don't because they think they're too young. I mean, Polly had helped our mother to write an advance decision to refuse treatment because she knew about advance decisions through her work, and she helped our mother to do one. She hadn't written one for herself because she was only 40 something and she was fit and healthy. She needed one. But again, one of the differences between dementia and acquired brain injury is you get your acquired injury in a snap. You know, the impact of the car, the stroke, the cardiac arrest, you're fine one day. your brain injured the next. So there's no time for planning. With dementia, at least, there is more of an opportunity when somebody first gets a diagnosis to say, do you want to think ahead to what may happen? And often people say, no, they don't want to, it's too depressing. So we've done a lot of work, my wife, Sue Wilkinson, and I, with people who do want to make advanced decisions to refuse treatment, to help them think through what it is that they want to refuse, under what circumstances, and also, of course, what it is that people would actually like to happen when they can't make decisions for themselves, and how they can also write advanced statements saying, if I can't decide for myself, this is the kind of thing I would like in terms of my social care, the television programs I like, the kind of food I enjoy, the kind of setting I would like to live in.
Well, Klaus Misch says, if we end up in a similar condition to poor Polly, is there a standard form that we can compete to make sure we're not going to be kept going against our wishes? I mean, to some extent, you've answered that. But I mean, how specific do you have to be? I suppose, actually, to be honest, I've been meaning to do this myself, but I haven't got around to it. I better do it at the end of this.
You had.
But it is slightly baffling. And when you say, well, you have to specify all these different aspects. Do you want to be fed via a tube? Do you want to be ventilated? That I think a lot of people find that really hard to. So what advice would you give if our message to our audience is get out and write your advanced directive, advanced decision? I mean, how do you go about that? Do you need a lawyer? Do you have to pay money for it, or no?
You do not need a lawyer. I would advise against a lawyer. I've seen some very bad advanced decisions drawn up by lawyers, sadly. The best online template is Compassion in Dying. So if you Google Compassion in Dying, you will get an online thing that you can fill in with advice along the way, a guidance on how to do it. And they have a telephone line that people can phone to get support, which is staffed by a nurse. So, but you can actually just pick up a piece of paper and write one. And some people who hate filling in forms, I didn't do their form. I've wrote my own. You can start by simply writing it. The legal requirements for an advanced decision to be effective are that you must have a signature, your signature. You must have a witness who saw you sign. And you must have a statement that says that the treatments you are refusing, you understand that refusing them may shorten your life. So those are the legal requirements. They're fairly minimal legal requirements. So it's pretty shocking to me that I keep seeing ones that don't meet those requirements. There's no witness signature, or the person hasn't included what I call the magic sentence, the bit that says these apply even if my life is shortened as a result. So it's a fairly minimal form. The difficult bit, I think, is, as you've suggested, is deciding, well, how do I know what I want to refuse? Do I have to write a great long list of every single medical treatment? For me, obviously, and my whole family looked at what had happened to Polly and thought, we don't want this to happen to us. What I have done is said that I do not wish to receive any life-sustaining treatments if I am not able to consent to them. Now, that is the most draconian advanced decision that you can write, because it means if I don't have capacity, even momentarily, then it's not lawful for you to give me medical treatment. Some people, quite a lot of people actually over 80, would like that kind of advanced decision and are happy to do that. Other people would prefer to say that if they don't have capacity, they would like medical treatment pending some sort of assessment realistically about how well they're going to recover. And then they need to say what level of, what quality of life would be acceptable to them. And for some people, there are absolute determinants. If I can't play my guitar, I don't want to stay alive. Or if I can't live independently, I don't want to stay alive. So don't give me life-sustaining treatment. So it's about figuring out what for you makes life worth living, what kinds of compromises you'd be willing to make to stay alive, and what you wouldn't. And then somehow getting that into writing so that you provide the doctors who have to make these decisions with your own decisions, and failing that, with guidance for them to help them figure out what kind of decision they need to make on your behalf. I think one of the problems for doctors is that there's so little from the person themselves sometimes. And doctors are often very grateful for these documents because it gives them some guidance about how to proceed and some support about knowing what the person would want or having a good idea from a document about what they should be deciding for them.
Mm-hmm. There's a great question actually from Kate Richards, who is the president-elect, I think, of the Royal Veterinary Association. And Kate says, really interesting, because as a vet, we act as advocates for animals, which can sometimes be at odds with what the owner would wish. It seems almost opposite in human medicine. She wonders whether there are going to be more people making advanced power of attorney decisions or filling in and making those decisions as the population ages. So power of attorney versus advanced decision, or do you think, should you do one or both? Do you think?
Both.
Both.
Yeah. Both. They serve different functions. So an advanced decision to refuse treatment only refuses treatment. You can't request treatment in that, and you haven't got a crystal ball. So you actually don't know what sort of situation you'll be in at the time that you write it.
Yeah.
By appointing someone with power of attorney, you've got somebody in place who can make decisions contemporaneously at the time that they're needed, when the decision needs to be made, and when you're out of it and not able to. So as long as you ensure that the two don't conflict, basically you need to say that your power of attorney can't make any decisions that you've already made for yourself in your advanced decision, then you've got belt and braces.
Mm-hmm. There are a couple of comments that people might like to look at. David Nichol is a clinician in Birmingham, also quite an activist, for a political activist, a really good guy. He's got a link up there to the compassionindying.org.uk. And Lucio Fumi says the Terence Higgins Trust form from 2007, originally written for AIDS patients. So he's advocating that. Francis Morgan says, on a practical level, is it likely that an advanced decision document will be honoured when they're often buried deep in the medical records in a patient? In an emergency situation, how can a patient's autonomous advanced decision be respected? I mean, that's a good question. Because I guess, take Polly's example, and of course of many others. I mean, acute car accident, they appear in the accident and emergency department. You've often got quite young clinicians all rushing around doing, everything. They're kind of trained to do everything, a bit like soldiers in the trenches. And I mean, it is difficult, isn't it, to in that situation, you have to give some kind of sympathy for the clinicians, but probably that acute decision whether to do everything or do something or do nothing, that has to be made there and then. So will those decisions be respected in that sort of situation, do you think?
I think the more urgent the decision, the less likely it is that the person who's giving a treatment in an emergency will have stopped to ask if there's an advanced decision or find an advanced decision. Mm-hmm. So it's no guarantee that you won't get treatment you would have preferred not to get, but it helps. It's your best chance of not getting treatment. I'm not for CPR. So I have put in my advanced decision that I've refused CPR. I have no confidence that anyone seeing me having a cardiac arrest wouldn't jump up and down on my chest. I've also, of course, asked to be registered as a DNA CPR with my local ambulance trust and got my GP to fill it in, because that's some better guarantee of that information getting to the person who needs it than is my advanced decision. So it's a question of trying to figure out how are people going to get the information. In terms of who knows about my advanced decision, there's no point writing it and putting it with your will, which for some reason people do. Your will is going to be read after you're dead. That's too late for your treatment refusals to be implemented. So there is an issue about making sure that people know where your advanced decision is and what it says. So all my family and friends have it. It's with my trainer at the gym. I summarize it to when I go on fell running competitions and things, so that whenever I'm in a situation in which I think it might be needed, I make sure that people know that it exists. So it is our responsibility as patients to make sure that the people who might otherwise give treatment are aware that we have refused it.
Mm-hmm. Yeah, David Nichol has come back and he says, makes 2 points really. One, that the public have a misunderstanding over complex brain injury, partly because of medical TV programs where, of course, people make miracle recoveries, don't they, on casualty and so on and so forth. And then 2, professionals at times avoid difficult conversations in relation to treatment withdrawal. I mean, probably from a doctor's point of view, it's easier, just to carry on the peg feeding than it is to stop it. Do you think that's an issue?
Yes. Hello, David. So yes, I think in the emergency situation, the issue is simply you do everything you can as fast as you can, because if you don't, you've lost the possibility of giving someone a life they would value. I think the real problem, and the thing that advanced decisions are most useful at addressing, is once the person is stabilized, once there's some kind of diagnosis and, more importantly, prognosis about the extent to which the person will make a recovery and what that recovery would consist of, which you can then match against, well, what for this person is quality of life, and what would they not want to live with. And that's the situation where it becomes very tricky, because the person's been rescued. The person is maybe on an upward trajectory now after the cardiac arrest or after the car accident. They've been stabilized and they're now healing. I know from my experience of talking to particularly nurses on the wards that they have formed what they think of as a relationship with the patient, and they're professionally invested in the kind of care that they give. And the idea of withdrawing or withholding some care, and particularly the feeding tube, which occupies a significant sort of symbolic force, it's food and water. That, of all things, people find it incredibly hard to withdraw. So I think, and they also feel that the feeding, they feel they're not making a decision. A decision is not being made. We're waiting and seeing. Or the phrase that I hear a lot is the patient will declare themselves, or we'll wait and see. It's too early to make a decision. And while this is happening, every day feed is being poured in, which is a medical treatment, but it's not being thought of as a medical treatment. So the law says that clinically assisted nutrition and hydration, ever since Bland, the first case that came before the court in 1993, the Hillsborough disaster, permanent vegetative state, the law has said that this is a medical treatment and therefore should not be given unless it's in the person's best interests. But for many family members and for many clinicians, it feels like basic care. Yeah. It feels like basic nurturing a person. It's food and water. It's not medical treatment. And I think that's a central conflict. And it's not even always a conflict. It's just a sort of, well, we're not doing anything special. We're just giving food and water the way we would any other patient. You can't withdraw that. That would be euthanasia, or that would be murder. And I think that's a real challenge at the moment. And certainly when Jenny and I have been supporting families who found themselves in this situation, and have spoken to the GPs involved and the people at the care home, we've encountered what Jenny and I would call conscientious objection to withdrawal of feeding tubes, which isn't labeled as such, maybe because it's not explicitly religious, maybe because the people who hold these views assume that nobody could be so bad as to take away food and water from a patient. So you find treatment being given by default.
Yeah, and I mean, it must be a bit agonizing, because I suppose once you withdraw that, it's going to take a week, maybe 2 weeks for the patient to pass away, to die. And that 2-week period must be difficult for the nursing staff. So that would be another. And actually, Kay Hyatt, thank you, Kay, for this question. This is quite interesting because it slightly takes the opposite view. Do you think that people have enough information about what impaired life might be like, so they're able to make a properly informed advanced decision? often people are very scared of living with impairment because there aren't good role models for that. And the assumption is that it will be worse than it actually turns out to be. I mean, what would be your response to that?
This is something that comes up every single time I support somebody in writing an advanced decision. They will say something like, I never want to be in a wheelchair. If I'm in a wheelchair, that would be awful. And what we know from the research, and probably from many of the people we know, is that people with particularly degenerative illnesses will often set cutoff points. After this, I no longer want life. And when they get there, they move the goalposts, because people are amazing. People accommodate. People find it possible to live with all sorts of conditions that they previously did not think it possible to live with. But the issue is not simply impairment here. It's impairment of the mind or brain that's at issue. An advanced decision can only refuse treatments once you can no longer make those decisions for yourself. So if you are no longer able to walk, and if a wheelchair is the right thing for you to retain mobility, and you still have capacity, you can decide at that point about whether you want that or not. The issue with advanced decisions is that it applies after you've lost capacity. So what I know for sure is that my advanced decision will work when I can no longer make a decision for myself. For me, that's a cutoff point. I don't want my life story to have what I would think of as a sort of coda, where I am a person who isn't anymore cognitively able in the way that I am now. I want my story to end my way. Not everybody feels that way. Some people feel able to let go and to live with, say, dementia, and to extract pleasure from those last years, even without cognitive capacity to make their own decisions. So I think that's a crucial decision. And of course, if you're going to be permanently unconscious, there's no opportunity to get used to your new situation. So for patients of the type that Jenny and I mostly work with, those patients are not aware of the situation that they're in at all.
Mm-hmm. There are a couple of things to read out. Pin Jen Chen from Taiwan says he's a geriatrician and one of the pioneers to introduce the structure of MCA England to the Taiwanese system. We frequently face stress from family members insisting life-sustaining treatments, but we don't have a court of protection to allow a quick judgment in the best interests of patients. I mean, that's a good question. I'll answer that first, and then Lynn Turner-Stokes, who I spoke to just before coming onto the program, actually has got a really good question, typically good question. So thoughts about, outside the UK, how do you see this internationally? Are you involved ever in beyond the UK in getting advice on these issues?
No, but I've been at conferences where people have talked about the systems in their countries. And I think the Court of Protection offers one of the best systems in the world for making decisions in a relatively speedy, it sometimes feels quite time consuming, but very careful, very considered, and very impartial, independent way of approaching decision making for people who can't make their own decisions.
Yeah. So Lynn, thanks, Lynn, for this question. He says, in law, it's the giving, not the withdrawing of treatment that has to be justified. But many clinicians think of it the other way around. Whoops, it's just disappeared now. See if I can find it again. That's the trouble with these things. Here we go. How do you think we should educate them to understand that continued best interest discussions are a legal requirement? For example, has a doctor or a trust ever been sued for giving unwanted treatment, and if not, should they be? That's a good question.
Well, yes, they have. There was a case fairly recently where an advanced decision to refuse treatment had been lodged in a patient's notes, and as a questioner earlier suggested, it kind of disappeared to the bottom and nobody engaged with it. And then at some point the GP informed I'm not sure I'm getting this quite right, but at some point it became clear that there had been an advanced decision for this person, I think 18 months earlier, after 18 months of treatment, and it went to court and the trust was sued for giving treatment that they should have known the person had refused. So it's treatment without consent. I think there need to be more of those cases. I am seeing a lot of treatment without that the person has refused, or a lot of treatment without best interests decisions being made. I suspect that making clear legally and demanding damages would be an effective way of helping professionals to understand that this is not acceptable. The more soft soap way is trying to educate through some of the online learning that Jenny and I have created, which explains that treatment can only be given if it's in the patient's best interest, and that crucially that you cannot decide what is in a person's best interest without understanding the person as an individual. It's not your view of what's in their best interest. It needs to incorporate their values, their wishes, their feelings, their beliefs, the way they lived their life, the sort of person that they are, the decision that they might make if they were able to in the moment that you're making the decision. And that is what I'm seeing so often left out of medical decision making. And that's what I'm seeing the Court of Protection put back in. And the most impressive aspect of the Court of Protection, which is open to the public, and anyone can go and watch a hearing, and I would strongly advise you to do that. The most impressive aspect is seeing the judges listen to the medical evidence and then say, so now tell me about the person, and listening to family and friends and colleagues and whoever else knows the person talk about what this person might want in this situation and what the evidence is for that is for a family like mine, for whom that was not done by doctors who dismissed our views, to see judges do that in court and to see them fully work very hard to fully appreciate the person as an individual is incredibly moving.
Mm-hmm. Gordon Caldwell says he's a consultant physician, and my experience is more wanting to stop treatments, but the family wanting feeding, etc., to continue. He lives in Scotland, and he says, how do I proceed legally to pursue the patient's best interest when there isn't a POA? I mean, is Scotland different to
Scottish law is different, and I don't know about Scottish law. I have occasionally been contacted by families in Scotland and have had to listen sympathetically and refer them on. But of course, there are families who seek treatment. My experience, and that of many of those that we work with, is of families wanting treatment to stop and doctors continuing. It's important to, of course, recognize that doctors' experience is also very often the other way around, where they believe that treatment is futile and should not be being given, and families are fighting for continued treatment. And I think in those cases, it's really important for doctors who are struggling with that to listen to and learn from doctors who are successfully working with families who start from that position, listen to those families and work with them to understand the medical facts, to understand what the future is going to look like, to understand what a miracle might or might not mean and the likelihood of it happening, and if necessary, to take it to the Court of Protection, because you should not be going on treating someone if you believe it's not in the person's best interests, whatever the family think. And this goes back to Lynn Turner-Stokes' question. It's not lawful to give treatment if you believe that it's not in the person's best interests. It's assault or battery or civil trespass. So whatever the family say, you need to take it, if you're in England, you need to take it to the Court of Protection in order to say, I think this treatment is futile and should be stopped, and it's not in the person's best interest. The family disagree. Please, judge, can you resolve this?
What happens if you've got one member of the family who thinks, feeding should continue, and another member of the family who takes completely the opposite view? I think we discussed a case exactly like that just before coming online. What would the Court of Protection help in that situation? It's a bit tricky.
It's necessary to go to court in that situation. So the law and the guidelines say that it is not mandated to go to court before withdrawing clinically assisted nutrition and hydration from a patient in a prolonged disorder of consciousness, if everyone is in agreement and if it's not finely balanced, if it's straightforward and clear. If people are not in agreement, then you must take it to the court. And that was the case that we observed. We sat at home and watched a case online. Court of protection hearings are now run through MS Teams and other online vehicles. And we watched a 2-day hearing before the Vice President of the Court of Protection, Mr. Justice Hayden, in which this was exactly the issue, in which the brother of somebody who had been in a vegetative state for 7 years said that it was not in the person's best interests to continue. His son found it completely ethically unacceptable to withdraw the feeding tube, and he had lived all over the world, and he launched an articulate moral argument about children in other countries walking miles to get water and starving people, and here in England you were going to starve and dehydrate someone to death. And the judge listened. He fed back, I understand this is what you're saying. He admired the argument and its intellectual cogency as a position to take, and he authorized withdrawal of the feeding tube. And there's a blog by Jenny, my sister, on our website about that case at the moment. It's just been published, and the judgment isn't out yet, but will be shortly. So where families disagree, yes, there can be some space for waiting and supporting families to come to a consensus, but there's no way that some families will come to a consensus. They have polar opposite views. So somebody has to make the decision, because the clinician cannot go on giving treatment that she or he believes is not in the person's best interest. So you don't just sit back and say to the family, well, when you've agreed together, come back, because that leads to the family member who takes the one position being ostracized by all other members of the family. It leads to family rifts. It's destructive of the family. In the end, it is the clinician's responsibility to decide this is not treatment I think is in the person's best interest. The family don't agree with me, therefore I need to take it to the Court of Protection.
Yeah. Well, this is a tricky one. Jeanette Alote, thank you, Jeanette, said, this happened to me when my premature infant was clearly beyond help, but the paediatricians insisted on striving officiously. What about parents of such children who'd be expected to care for a brain damaged child? Are you able to?
First, I'm so sorry. I mean, what a horrible situation to be in. Mm-hmm. I only work with adults. I can generalize to say that over medicalization for adults in the Court of Protection is almost certainly reflected in over medicalization for children in the family courts, as it is with childbirth and every other area of our lives that comes under doctors. But I have no experience of working in that area, and I'm really, really sorry.
Yeah. And there's another question about pediatrics from Miriam Feingould. And so, I mean, I think it's even more difficult, isn't it, from the pediatric point of view? But John Newland, thank you, John, says, what happens to someone who's never had capacity, but then experiences a catastrophic medical incident, assuming a brain damage is talking about there? What that's a particular situation, isn't it?
Yeah, so learning disability comes up quite a lot in the Court of Protection. So people with a kind of learning disability that means they've not had capacity to make medical decisions, or they've never had capacity to decide where to live, or they've never had capacity to decide to have sex with someone, or they've never had capacity to decide who to have contact with. I mean, remember that capacity is decision specific. So we're looking at quite a range of different decisions. If somebody has never had capacity to make a given decision, you're limited to a best interest decision based on their current wishes, for example. So some people who've never had capacity can express very strongly the view that they want to live at home and not in a care home, for example. They may not have the capacity to make that decision, but they can express very strong views about their wishes. If somebody is nonverbal and can't express their views in words, nonetheless, they may show through their behaviors that they want one thing and not another thing. And again, those would be taken massively into account in a best interest decision. And they are. I see that being done in the court. Mm.
Yeah. Tracy Elliott says, do you think the position has improved since the decision of the Supreme Court in the NHS Trust versus why. We were talking, weren't we, about a bit about this? I mean, just tell us a little bit about that situation, Celia.
So we were talking about that because you asked me what that I had done was I most proud of, and I said I'm most proud of the work that led up to the decision in Re-Why and what's happened subsequently. So in the Supreme Court, a case was heard in which, so a family, there was somebody in a vegetative state, and instead of applying to court for permission to withdraw the feeding tube, the clinicians, the trust, applied to court for a decision that, in fact, you didn't need to apply to court. So there had been an assumption in law that you needed to apply to court before withdrawing a feeding tube from someone in a prolonged disorder of consciousness, and the Re-Why decision overturned that and said no, as long as people are in agreement and it's not finely balanced, there is no necessity to apply to court. And behind that decision was a phenomenal amount of work by a multidisciplinary group of clinicians, including Lynn Turner-Stokes, and lawyers and IMCAs and people, me and Jenny, people who work together because we believe that once it's been decided what's in a person's best interest, then that should happen without delay. And the court was causing this huge amount of delay because it was taking months or years for issues to get to court. And worse than that, the hand of the court was reaching backwards to mean that people weren't making a decision about clinically assisted nutrition and hydration not being in a person's best interest, because if they did, they'd have to apply to court. So the whole question was being shelved, and it just reinforced the sort of treatment by default that was going on. So yeah, that decision was a great decision. Things have definitely been better since then. We know because we've been working with some families since then for whom ongoing, some of those families have contacted us saying, we read in the newspaper that you don't need to go to court anymore. So now we wouldn't feel like criminals by saying, we don't think continuing treatment is in our father's, mother's, son's best interest. Can you help us tell the doctors that we want treatment withdrawn? And things have moved much more swiftly because they haven't needed to go to court. So that was indeed a good decision, and one that Jenny and I and colleagues were working quite hard through various other mechanisms to do with court practice directions and the guidelines to ensure that best interests could be implemented as soon as possible.
And that was in 2018, was it? Am I right, where that key decision was made?
Yes.
Right. We've got 2 minutes to wait, so we have to stop. Although actually we've got 29 questions. And I'm sure that people will me because I didn't get to answer, ask you enough of them. But I was talking to Lynn Turner-Stokes just before this, and she said that the thing about you and Jenny was the 3 A's: your academics, you involve in advocacy, and you involve in activism. So the 3 A's kind of summarize the amazing work that you've done, and so congratulations to you, Celia, and thank you so much. And please say hello to Jenny from me, because I was really touched by her description of poor Polly's case there a number of years ago. But don't go away, because I've got a few announcements to make, because we've got a busy week coming up for the Royal Society of Medicine. Remember that you can apply to join to be a member of the Royal Society of Medicine. We're looking for members. You don't have to be a doctor. Anybody interested in medicine or indeed in health can join, and we'd love to have more members. Our building is now open, so you can come and join us, and we're beginning to start our conferences again after the pandemic. So things are hotting up at number 1 Wimpole Street. Well, tomorrow we're talking about the global pandemic response. Claire Bainan, one of our trustees, is talking to Professor David Heyman, probably world expert on the pandemic. On the 8th of July, we've got a spotlight on long COVID. That's a special 2.5-hour program. So we'd love it if you would sign up for that. We're talking about planetary health as part of our climate change series on the 6th of July. And next week in Conversation Live, we've got Professor Charles Knight, who is a top cardiologist from Barts, and he'll be telling us about setting up the Nightingale Hospital and all the amazing work that they do in terms of cardiac and stroke and so on treatment at St. Bartholomew's Hospital. And the week after that, very excited, Simon Wesley will be interviewing the famous historian Tom Holland, who's written some amazing books, including Rubicon and a bunch of others about the ancient world, particularly the Roman world. So remember that this is free to you, but not free to us. So if you do feel like making a contribution to the Royal Society of Medicine, particularly since we've been hammered by the pandemic, we've got a big deficit that we have to make up. We want to keep the RSM going for at least another 100 years. So please do make a donation if you're feeling generous. And thank you again, Celia. I mean, you were just so delightful to interview, because all I did is ask you a few questions and you just talked away and told us amazingly sensible things, which I'm going to rush off now and do my advanced directive and power of attorney to my children. So I've listened to you, and I'm sure lots of our viewers will. It'll be on, this program will be available on YouTube probably tomorrow. Do fill in the feedback form. We'll send them to Celia so she can read your opinions of this session, which I think has been brilliant. Good night, everybody.